First of all, thank you for taking the time and giving me the chance to talk to you. Hopefully you'll get as much out of this as I hope you will get out of this. This is definitely a topic that is near and dear to my heart. I've been back in the day when I lived in Pittsburgh, I practiced law. I ran the technology practice for a 450 lawyer law firm, represented hundreds of startup companies every year, represented large companies doing deals with startup companies. And the one thing that was clear was that most people had very little practical understanding of intellectual property rights. So we're going to focus a lot on copyright because that's really on the topic that seemed to be most important to all of you. But I've given you a handout. If you don't have it, there's more copies right here. This is a little cheat sheet that I created summarizing the 4 major food groups of intellectual property: patent, copyright, trade secret, and trademark. And I did all of it because if one thing people get wrong more than anything else is knowing the difference between patent, copyright, trademark, and trade secret. I'll hear all the time people say, well, I have a trademark on this, but they're talking about a copyright. Or they say they want to patent this, but they're really talking about, a trademark. So the topics are complicated. They're confusing. The one that's the most fun is actually copyrights. That's why I'm kind of excited that that's what we're going to talk about mostly today. So before I begin, does anyone have any background in intellectual property that I should know of? No one's going to drag me out for having told a fib or something? No? All right. So let's just start overview for a second with intellectual property. What is it, right? There's tangible property, your computer, that remote control, the stroller. There's real property, this building that we're sitting or standing in. And then there's intangible property, or intellectual property as we like to call it in legal words. The idea being that there are ideas, thoughts, things that you can't physically touch that deserve some sort of protection, some sort of property right that in at least most of the developing countries we respect and try and protect. Not every place in the world has the same views of it, so I am focused on the US for the moment here. But since we are talking often in the internet, there's a lot of laws that get brought into play, whether it be Canada, Europe. You see stuff on the internet, you don't really know where it comes from. So in the intellectual property space, we do have these 4 major food groups: patent, copyright, trademark, and trade secret. Some of it begins with actually the US Constitution. People don't realize. Article 1, Clause 8, Section 8 of the US Constitution says that Congress shall promote the useful arts and sciences, ... And that is the basis for hundreds of years worth of intellectual property law, because Congress shall promote the useful arts and sciences. Arts, copyright. Sciences, patent. That's kind of the basic divide. Trade secret developed as an adjunct. It's more akin to patent, but it's different in its own right. And trademark developed sort of as an akin to copyright. So a lot of times when I talk about copyright, I might touch on some things that might sound like trademark, and that's because they are very similar. Take, for example, a logo. The NBC logo, with the old peacock and the beautiful tail, that is a trademark of NBC. It's also a copyrighted work. So these things often do run hand in hand. So really quickly, trade secret, because it's the easiest. If you have a secret, you keep it a secret. Somebody misappropriates your secret, you might have rights against them. You don't keep it a secret, somebody takes your not kept secret, you have no rights against them. Seems kind of simple. There's thousands and thousands of cases. When I was in law school, I worked for a professor of artificial intelligence in feeding into this artificial intelligence computer system at University of Pittsburgh thousands of trade secret cases to help the computer figure out how to argue those cases. It's extremely complicated in the end because it relates to, is there in fact a secret? Did you have a reason to believe that your efforts to keep something a secret are in fact a secret? There's the old case of a building that held a big factory with a proprietary process inside, and they hadn't built the roof yet on the building, and somebody flew a spy plane overhead, took pictures from overhead, was able to figure out the process because there was no roof on the building, and that was deemed not to be a protected trade secret because they should have put a roof over the building. Okay, who would have expected a spy plane flying overhead with a guy with a camera taking the pictures? But, you know, needless to say, it's complicated, but it's not in the sense that there's not a hard and fast law. It's not like you must do this, you must file this, you must pay this fee, and therefore you have a trade secret. Trade secrets are really about having something, keeping it a secret, and making sure that you do everything possible to keep it a secret. Patent, which we're not going to spend a lot of time on because it's not really as applicable to the kinds of things you're all talking about right now. But patent, as I said, was Congress promoting science. And the idea of a patent is to give somebody exclusive rights for a period of time in exchange for publicly disclosing to the world what their invention is. That's the basis of why we give a patent. It sometimes gets a little bit crazy, like when Amazon got a patent on the one-click. So click one click and they automatically ship it to the address that you have stored in the database as your primary address, and the product shows up the next day at your house. They were able to get a patent on that back in the mid to late 90s. And doesn't seem all that inventive, although when they first thought of it and nobody was on the internet, it was pretty inventive. So sometimes patent law is less about promoting arts and science. It seems to restrict people from doing what they want to do because someone else has a patent out there. It's definitely the most expensive area of intellectual property. Basic filings are going to range anywhere from $5,000 to $25,000 in legal fees just to get a patent issued. It'll take anywhere from 1 to 3 years for it to happen, in exchange for which you get, depending on where you were at any point in time, patents were either 15 years, 17 years, or now 20 years in duration. So they're very complicated. The key is it only protects inventions. It protects novel, not obvious inventions, things that people skilled in the art had no idea or wouldn't have thought to do but for, you know, this invention that you came up with. So those cover kind of the two science-oriented pieces. Any questions about any of those? Just because I don't want to gloss over something if you really have a burning question. Nobody? Once, twice? Okay. So we get to trademarks and we get to copyrights. And again, this relates to the idea of protecting arts. A trademark, very simply, is a mark. It is a sound, an image, a color, possibly even a smell, that is equated to a particular product or service. So if you were to see that little green face on a white cup and has like the stars and the moon around it, right? You all know that you just had either a Starbucks coffee from Starbucks, or maybe you went to a hotel that served Starbucks coffee, or maybe you went to the grocery store and they were selling Starbucks coffee. So interesting, Starbucks, right? There's Starbucks the store. There's Starbucks the beans. There's Starbucks in the cup with the steam coming out and the little green thing that keeps the steam from coming out, right? So that's a mark that's tied to not one product, but tied to lots of products. Trademarks are product specific. Trademarks apply to specific categories of products. In the trademark world, you can generally get trademark rights by using a mark in commerce over time, and those rights vest in you as you use it with respect to that product or service in that market. So if you had a coffee company 40 years ago in Syracuse, New York, and you chose to call it Starbucks Coffee, and you didn't do anything other than start using the name and start selling coffee, you would have rights for selling coffee in Syracuse. And when this company in Seattle starts developing coffee and wants to come to Syracuse, they would in fact be infringing on your rights because you had those prior rights. As it turns out, Amazon was a bookstore somewhere in the Midwest, well before Amazon.com ever came about. And so the only way that Amazon can continue to operate on the internet was to buy the rights to that name, because otherwise they could be precluded from using the name in that town in the Midwest where there was an Amazon bookstore.
So just the fact that this existed prior copyrights, they didn't have to take any special action or file anything? Or?
Trademark rights exist at two levels. There's common law rights. We're in the common law system here. We follow the British system of, courts interpret laws, and those decisions in court render opinions that bind all of us based on, even though there isn't a specific law to that specific question, the court can make that determination. That's a common law right, as opposed to France, where they have a civil code, and it's very different. That's why if you go to Louisiana, I don't give seminars in Louisiana because it's a totally different law down there. Or Quebec. I did a deal in Quebec a long time ago, and I was, besides the fact that every contract was in French, which I didn't speak, they're very different over there. But in the civil common law systems that we have here, you can get trademark rights just from the mere fact of using a mark in commerce with respect to a product or service. But those rights are limited to the product or service in the geographic market where you in fact do use it. Anytime you see TM or SM next to a mark, that is somebody designating common law trademark rights or service mark rights with respect to that mark. There's no requirement you do it. It's just a good idea. If you feel it's a mark, it's putting the world on notice. It's saying, hey, I treat this as a trademark of mine, so I have these rights. When you see an R in the circle, that reflects a federal registration. That's where you actually file with the U.S. Patent and Trademark Office, pay fees, go through a prosecution process, and get a trademark issued, and then continue to do what's required under the trademark law in order to continue to maintain those rights. If you put an R in a circle when you don't have a trademark registration, the Trademark Office will forever bar you from ever getting a trademark registration. So don't ever do it unless you in fact have a trademark. TMSM, perfectly fine. Do you have to do it every time? No. Do people tend to do it like the first time? If you have a website, you put it on the first page. Do you have to put the TM every single page after? Of course not. The idea is to just put the world on notice, hey, I assert trademark rights to this. Now, trademarks, as I said, could be words, they could be sounds, they could be colors, they could be motion. So one of the movie theaters, they have, Mandalay, I think it is, has the tiger through the grass. That vignette, that motion video is a trademark of theirs. The stars over Columbia Pictures, I think, one of the movies, same thing. That's a trademark of theirs. And B, C, those three notes. You hear those three notes, as long as you're at least 40 years old, you know what that means. I sometimes have to, I teach at SU sometimes, and I say these things, and they look at me like I'm absolutely crazy, and I remember that they have no idea what those three notes are. But anyway, that's an example of notes. Owens Corning. You see pink fiberglass. Who owns it? Owens Corning. Guess what? Fiberglass is not pink naturally. Fiberglass is yellow. They color it. They dye it to be pink. They were able to get trademark protection on the color pink for fiberglass. There's a whole series of complications around trademark, and if people have more specific interest in trademark discussions, I'm happy to go into them. I will gloss over them right now by just saying that there are good marks and there are not so good marks. Totally unique words, made up, things that are just made up words, Exxon, Kodak, you put letters together, you make a word, that represents the best trademark you can have. Arbitrary. So take a real word, but use it arbitrarily. Apple for computers. I don't know, Burger King, right? Burger is a real word, but king is arbitrarily applied to burgers. Why would you do that? So when you take real words and you arbitrarily apply them, you have trademark protections in those uses but you don't prevent anyone else from using it in other products. So someone can have an Apple real estate company or an Apple carpet company. We used to be able to say, if Apple were to, Apple Records, because Beatles, for Beatles fans, Apple Records, right? Well, Apple had to cut a deal with them because Apple got into music. If you were to say, if somebody wanted to make an Apple Watch company, well, guess what? Now Apple's in the watch business. So, as you use your mark in commerce with respect to different products and services, your rights expand into those different products and services. But when it's an arbitrary mark, it only applies with respect to those products and services you, in fact, do use it. As opposed to an arbitrary word, it would be really hard for somebody to take a totally made-up word you came up with and then use it with another product and say, hey, this is my mark now. When you get into descriptive or suggestive marks, one of the greatest suggestive marks is Microsoft. Microcomputer, software, right? It's not a very good trademark. But after using it long enough, there isn't anyone in the world who hears Microsoft and doesn't equate it to the company out in Washington, right? So there is a thing in the US known as the secondary register where if you use it for 5 years, you can apply to the trademark office and say, granted, my mark wasn't that great to begin with, but now everyone really means me when they see that. That's how, in fact, Owens Corning got pink for fiberglass. You couldn't get it out of the gate, but the fact that they could show, they actually did a study and they laid out fiberglass and they said to people, which is Owens Corning, and they all picked the pink one. And they were able to show that the market equates pink fiberglass to their company. So trademarks are very powerful because trademarks can prevent somebody from engaging in commerce in a way that would be confusingly similar. Those are kind of the buzzwords. It's also very, it's come up a number of times in cases, particularly involving religious organizations, because of what's known as anti-dilution protection. If you have a registered mark, one of the things you can do, if somebody wouldn't necessarily say that it's confusingly similar between these two marks, if you could show that the use of the other party's use of that mark would dilute the value of your mark, you have rights. So there are cases of, for example, parody where they've taken existing trademarks and used them in pornographic settings. And while there's no confusion between those two, you can, on the basis of anti-dilution, prevent somebody from diluting the value of your mark if, in fact, you have a registered trademark. So that's trademark in a nutshell. Any specific trademark questions that people have before I go to the copyright, which is where I think a lot of the fun will sit? No? All right. And I apologize, I didn't set the temperature in here. So copyright. Copyright, go back to the Congress shall promote the useful arts. Copyright is there to protect creative expression fixed in a tangible medium. Those are the two buzzwords. Creative expression fixed in a tangible medium. Something that's purely ephemeral is not protected by copyright. So a dance performance is not protected by copyright. A video recording of a dance performance is fixed in a tangible medium. It's therefore protected. There's a big case that involved a fireworks company that would set off fireworks. The fireworks show is not protected by copyright. They explode, they go away, it's ephemeral. But the recording of it is protected. It's why whenever you see things like a football game, they always have this recording is broadcast is protected by the National Broadcast Association and the NFL, blah, blah, blah. That's all because they're trying to tell you, hey, you can't copy my broadcast of this because that's my rights. The fact that a football game took place on the field, no rights whatsoever. If there is, yeah?
So the copyright would not apply to your example of the dance or the football game, me doing this.
Right. Well, and that's where they have their rub. They try for the longest time. You go to concerts and people, you go to the concert now, and it used to be that hold up a lighter. Now you think everyone's holding up their cell phone because it looks like a lighter. No, they're all recording the entire concert, and unfortunately, the industry doesn't like it. But there's not a lot they can do because what are they going to frisk everyone that comes in and tell them to give up their phone? It was easier when that video camera, you couldn't walk into the concert, with the video camera. They could stop you, but you can't go, they can't say, give me your phone. And so for that very reason, what they now say is if you look at your ticket, it will say it's illegal to record this while, so they're trying to use the contract of buying the ticket as a basis of you agreeing not to make a recording.
So
they could ask you to leave, but they don't.
You could be prosecuted if you sold it, right?
Again, it would be pretty hard for them to start No one has truly tested some of these provisions. In the old days in software world, we had what are known as shrink wrap licenses. And so go way, way back to when I first started programming in the late 70s. Software was thought to be a purchase. I bought that piece of software, I could use it. And then in the mid to early 80s, they started to interject these license agreements which said, you only have the right to use this software under these specific terms and conditions, only on one machine, you can't make a copy, you can't give it to somebody else, you can't resell it, you can't. And so in the early days of copyright and shrink wrap licenses, they were called shrink wrap because they were shrink wrapped inside the box. Until you opened the box, you didn't know what these terms were. And so the first cases said, nobody expects when they buy software to open it up and have these additional terms thrust upon them, and therefore they are unenforceable contracts of adhesion. When they went to the store and they bought that software, no one knew that those terms were there. So what the software companies do? They put it on the outside of the box. So you turned over the box and see, we had it there. And there were some cases back and forth on that. Then you start getting to the internet and click I agree. How many of you read it? Right? Guess what? You're clicking I agree. You are affirming. And so the courts over time, we used to say that, because I was very early in this era of practicing law, I had more than one judge ask me if I was old enough to practice law when I started, because I looked very young and I was young. But I was like one of the only guys doing technology deals. I was the only person out of 240 kids in my law school class that had a laptop. That's, put it in perspective. I had to carry an extension cord with me so that I could have the plug outside in the hallway because the battery wouldn't last through class. It was pretty embarrassing. But I was the tech guy. And so we would make up law. And we would say, do it this way, and hopefully someday it will become the law. And in fact, that's what happened. The courts evolved into saying these terms, everybody expects when you buy software that these additional terms are put on, that you're only licensing. It was like a complete reversal. So by doing something unenforceable for long enough, not illegal, just unenforceable, made it enforceable. So as an example of where the law ultimately caught up, no one's really tested this question of when you buy a ticket and they say you can't record this, yet they're not enforcing it against 20,000 people that are all sitting there, and they come after you. Not clear exactly what the outcome would be. They would try, possibly. Of course, you had those cases with the Recording Industry Association of America and the MPAA, the Motion Picture Association of America, where people were using file sharing systems and putting music and videos and all these things being, Napster and all the variations that evolved over time from Napster. And the idea of sharing videos that way, a lot of these people said that it was completely permissible because there were non-infringing uses for the platform. Go back, how many people here remember the Betamax, right? Betamax was the better of the two video tapes, but it lost to VHS as the format of choice. And Sony, who at the time was developing the Betamax, was sued by Universal Studios because the Betamax allowed you to make a copy of a movie or a television broadcast and violate the copyrights. And the court case that evolved out of that was to say Sony wasn't infringing. Sony made a tool that allowed you to infringe, but there were non-infringing uses because you could take a video of your own family and watch it. Of course, nobody had video cameras back in those days either, but don't let the facts get in the way of a good decision. So they're going to allow the Betamax to exist because while it had infringing uses, it had non-infringing uses, and so we're not going to prevent the non-infringing uses just because there are some infringing uses. Napster tried to argue the same thing. Yeah.
Sorry,
It's okay.
but that goes back to like at my school we have a musical and we bought the rights to do the musical with the children. We bought
Right.
the pamphlets, the music set, and then we videotape it. Can we put that onto our website?
Yes. Because music is a really, really interesting and super complicated area. My cousin is a music lyricist and a publicist. He's written shows. Has hundreds of gold records, and he wrote Copacabana, many of you may have known. So Barry Manilow is sort of like a regular occurrence in our family. And so when you hear the complexities that as a writer he has to deal with, it's fascinating that the industry even exists today. Because in music, there's protections at the music and lyrics level, there are protections at the recording level, and there are very specific statutory guidelines for rebroadcasting of the recording level. So back in the day when we had record stores where you can go out and actually buy records, they were permitted to play music in their stores without violating the copyright on the basis that they were not infringing because they were helping to sell music. Radio stations said, that's what we do. We play music because we help sell records. No, they play music because they sell advertising. And so they were not afforded the same protections, and so the Copyright Act has a whole slew of provisions for how they go about playing music and how they pay for it. And there are statutory payments that are made to protect the recording artists, and there are also negotiated payments that relate to underlying rights that exist in the copyrights. So when you buy those pamphlets with the notes and the words, you're buying the rights of the author, the rights of the party who wrote the lyrics and the words, and they get paid through ASCAP and BMI for those sales. So the company you bought it from turns around and records the sale to these people who then collect the fee. So your purchase included some royalty in it. Your recording, the performance, is not a violation of the recording. You're not duplicating this recording. Where Google has a problem is when you take a piece of music and you put it underneath your video that you create, you post it to YouTube. Now you've taken somebody's recording, not the underlying words and lyrics. So music gets very complicated because of this bifurcated rights between the author and the performer. Now, back to the Sony for a second. So Sony, non-infringing uses, infringing uses. Napster, they said, oh, we're just like Betamax. Non-infringing uses, infringing uses. People could use this technology for non-infringing uses, like sharing big files with each other, PowerPoint presentations that they want to share. Of course, nobody was doing that, but yeah, we'll go with the argument for a second. But there was another problem. Sony says, I sell the video machine. I have no way of policing you. I have no way of controlling what you do with it. Napster said, same thing. We have no way of controlling. This thing is out there. There's no way to shut it down. Once it's out there, it's going. In the middle of the trial, hackers brought Napster down. Most people believe that the RIAA paid them to do it. No one knows for certain. But in the middle of the trial, during a demonstration, hackers crashed Napster and proved that it could be taken down. And the moment that they did that, the court had to rule that Napster, infringing, non-infringing uses, totally agree with you, but you have to police and stop the infringing uses because you could stop the transactions midstream, as opposed to Sony, who sells a VHS machine that you hook up in your house and they don't, knock on your door and say, what are you recording right now? So got very, very complicated. All of this, though, goes back to the idea of what are we protecting? We're protecting creative expression fixed in a tangible medium. Does not protect ideas. Does not protect data. Does not protect against somebody independently creating the exact same thing somewhere else in the world at another point in time without copying. Copyright is, in some ways, really messy and really prolific, and in some ways it's an extremely thin level of protection. unlike patent, which says you can stop somebody from making this invention if you have a patent on it, copyright says you have the exclusive rights as the copyright holder to reproduce, to display, to publicly perform, to make the sale of your copyrighted work. But it doesn't prevent someone else from independently developing the same thing. So if two people created the exact same picture at the exact same, two different parts of the world having never met each other, there would be two copyrights. Very strange. Now, for that reason, a lot of people on the internet try and do things to mark what they do so that it's clear that it is in fact theirs. There are services that can look for the digital footprint of a picture file to see whether or not it's in fact the same at the bit level. Not the name of the file, not the file size, but at the bit level, do the ones and zeros line up exactly the same? And if so, they can show that it was a copy. Some people embed watermarking into their images, or they put fake things into their images, that are unique and distinctive for them. Ultimately, copyright provides to the author, the person who creates it, the exclusive rights that I mentioned for a period of time. That period of time varies. It used to be life of the author plus 50 years. That was the old phrase. It became life of the author plus 70 years when Steamboat Willie was coming up for the 50th anniversary after Walt had died. Or it was coming up on back then it wasn't tied to his death, it was tied to another date, but they needed this extension. So Steamboat Willie became we refer to it often as the Disney Amendment, which took the copyright term to the life of plus 70, or there's another concept in the copyright law which is called a work made for hire. If I'm a company and I employ somebody to work for me and they create a creative work, how do I know when they die? To be able to track how long my copyright lasts, right? So they put this concept in called a work made for hire. And there are a couple of places where it comes up. Most obvious is the employee working for an employer that creates creative expression within the scope of their employment. The other is in the case of like a contribution to a collective work. So an artist that creates a sculpture that's part of an installation that has multiple sculptures, that could be a work made for hire. And there are very specific rules around work made for hire. Those have a term of either 120 years from when they're created or 95 years from when they're first published, whichever is earlier. So you can't create it and sit on it forever and have it keep, going because you haven't published it yet. So it's the earlier of 95 years from publish or 120 years from creation. Those, again, used to be 75 and 100. But with the Disney amendments, they bumped those up 20 years. Getting copyright protection is probably the easiest. Pre-1976 amendments, works that were created prior to 1989, there were very specific requirements about marking the works, putting a copyright notice, et cetera, et cetera. After that, it became very clear that creating work that is a creative expression fixed in a tangible medium immediately creates copyrights. You don't have to do anything. You should do something, but you don't have to. If you put a copyright notice on the work, copyright, C, date, name of the party that owns the copyright, if you put a copyright notice on it, you avoid somebody making the innocent infringer defense. Oh, I didn't know that was protected by copyright. Look at the notice. So you'll see things that are completely not protected by copyright with a copyright notice on it. It's thrown on everything. Again, it's not illegal to do so. It's not going to be enforced. If it isn't, it will be enforced if it is. So when in doubt, you'll see people throwing it all over the place. The other thing is that you can get a registration for your copyright with the Library of Congress. The Library of Congress, for those who saw the movie National Treasure, when he breaks in and all that stuff, that building keeps a copy of every registered copyright that's made. And there's a simple form and a small fee. I don't even know what it is today. It used to be $25, then it was $35. Maybe it's $50 filing fee. The form is generally pretty straightforward. There are different forms for different kinds of works. There's one for visual arts. There's one for literary works. There's one for musical compositions. But you take the form, it's 2 pages, you fill it out, you send in copies of your work with the copyright registration and the filing fee, and you'll get this nice little thing in the mail with a gold seal on it. So you'll see, companies that talk about how they have a copyright on their work, and they have this picture that looks all official of the seal on their copyright, but the protection of that work is generally not as big as they might present it to be on the website. But with that said, a lot of people don't do anything to protect their copyrights. Why don't they? Either 1, they don't know, 2, they're too lazy, 3, it can be a little annoying if you continually are releasing a new image every day or a new song every day to constantly file it. But by registering your copyright, first of all, if you ever want to sue for copyright infringement, you have to register prior to your lawsuit. But you can register at any point, but you have to do it before you bring your lawsuit. If you registered it before the infringement occurred, you can get statutory damages. And this is where, anyone here ever heard of the BAA? There's an organization that goes around to organizations and investigates them for copyright infringement on software usage. So they come in and they look at whether or not you have unlicensed copies of Microsoft Word on computers, whether or not you have unlicensed copies of whatever on computers, and they are paid by the license companies, so Microsoft and Adobe and all the big companies, to take that information and find those that are infringing, collect the money, and distribute it to them. And they use the money to go after the next party and the next party. And they rely on the statutory damages provisions because it can be as much as $100,000 per violation. So, you got a small company, you have 8 employees, and you have 8 copies of Microsoft Word that are illegally installed because the person who was doing your software never went and paid for a license. They just took the disk they had and they installed it on every one of those machines. And the BAA comes in and says, please pay us $800,000, because you have unlicensed copies. Say, oh, well, I'll just go buy a copy for $100, online right now. Oh, no, you infringed the copyrights. Give us $800,000. And so then you got to get the lawyers involved, and then the lawyers negotiate, and in the end, it becomes a painful yet not ridiculous fee, which goes on to continue to the next and the next and the next. So organizations protecting yourself against the rogue employee that installs software by mistake, that's the reason why you want to do it. Not because Microsoft's coming, it's because the BAA is coming. And then as it relates to the question that was posed to me in an email before this is the very last page of what I gave you. And it talks about something called fair use. And fair use is a topic that is very misunderstood. And a lot of people think it applies across the board to all forms of intellectual property rights. But the fact is, it is only part of the Copyright Act. And in fact, you would find it in Section 107 of the Copyright Act actually codified in there. It's about this big. And it says that it is not an infringement. You can, in fact, use somebody's work if it meets certain criteria. But it's not a bright line. It's not a hard and fast rule. It's based on all the facts and circumstances to be determined by a court. So what are some of these? Number 1, purpose and character of the use, including whether the use is a commercial nature or is for nonprofit educational purposes. So as a religious institution, that's often, yay, ding, we got that one. Not for profit, right? Number 2, nature of the copyrighted work. So in this case, how creative is the work? How much of the work is being used? Could you find another way of doing what you're doing without copying that work? The amount and substantiality of the portion used in relation to the copyrighted work as a whole. So in the case of music, you often hear the sampling of pieces of one song into another song. The very nature of sampling and why you're doing it requires that you, even though it's only a small piece, requires that you pay a license fee to do it. Cases have kind of held that. But if you take a paragraph out of somebody's article and you copy it for purposes of what you're using it for, is that one paragraph out of a big article an infringement? Effect of the use upon the potential market for or value of the copyrighted work. So by you making this copy, are you taking away from the commercial nature of that work? And this is what's gotten a lot of people in trouble. So universities, not for profit, educational purpose, we think we're all good, and we're going to charge you $50,000 a year to come here for school, and we're going to charge you $50 for photocopies for the class with all the handouts, which are going to be photocopies of these articles that we've put together for you. And they've gotten in trouble. Why? Because they copy the entire article. They're making $50,000 in tuition for, you know, in effect, stealing other people's copyright as the basis of what they're teaching. And they end up teaching off of the entire piece of work, so they're not just taking snips and bits and pieces of it. And so they end up now saying to the students, we have one copy on file at the library. You can make photocopies of it yourself, but make sure you're not violating copyrights when you do it. Basically putting it on you. The other one, and I had to look for this one. I did not know this case before, but in 2000, Worldwide Church of God sued the Philadelphia Church of God for the Mystery of the Ages book, which was a copyright owned by the Worldwide Church of God, which was out of print. And so the Philadelphia Church of God copied the book and distributed copies of it. And while initially the district court said that it was for not-for-profit religious educational purposes, and therefore it's reasonable, it's fair use, ultimately the appellate court held that the reproduction of the text was neither transformative nor purely non-commercial. And it took away from the economic value of the copyright holder's work by doing this, even though it was out of print. Nobody seemed to make a big deal about that. I think that was a little bit speculative myself. But ultimately, they said that it tilted the scale against fair use. So this was a case of one church stopping another church from copying their works. Now, there are a lot of works that are expired on copyright. Why are there so many Moby Dicks out there, right? Because the copyrights have expired. They only last for so long. But if you, in fact, copy somebody's existing work, whether it's an image for your website, whether it's, you know, taking an entire article and putting it up on your site, those things can amount to copyright infringement. It's kind of strange, but it can.
You give credit to the way you do it.
So that's often a great practical solution, right? Is attribution and credit, linking back to the site where it came from, so you don't get, someone doesn't argue, well, you took away business from my site. My site sells advertising, and now there's people that, hey, look, I helped promote you. I gave a link back to where your site was. Or, you know, making sure, one of the things that often gets used in the favor of copyright fair use is criticism. So if you're using the work in the purpose of comparison, critique, you know, here are 2 or 3 or 4 works that are put together, and as a compilation, you're showing different views, different sides. That can help in strengthen your arguments why it is fair use in that case. You're not just shamelessly copying somebody else's work. You know, how Google gets away with having every single image scraped and put up on their images search, you know, they seem to get away with it. It's not, this is one of those cases where I say it's a very gray, not bright line area. And so the best thing to do is to use as many of the nuances to try and strengthen your position. Attribution, the way in which you present it, you know, is it embedded into your site, or is it a link to a PDF or a link to a JPEG that gets pulled up as you're using it? Things along those lines to try and bolster this idea that it's not just a plain old copy, but leverage the fact that you all have the greatest one, which is the first point, which is non-profit, educational, you know.
So, like, for the question Amanda asked earlier, where they purchased the rights, would that even be necessary under fair use? Being like, because if they're just doing for like kids doing a production for the parents, do they need to purchase rights for?
It's one of those areas where, in a strict interpretation, you would say you shouldn't have to. But ultimately, because of some of these arguments of you're taking away commercial use, you know, that it's better safe than sorry, particularly when it comes, the Recording Industry Association, the MPAA, ASCAP BMI, their sole existence is to protect those rights. So you have a vested interested party. The BAA for software. You have a party whose sole existence is to go and protect those rights. Unfortunately, artists like photographers haven't had the same unionization of their rights as some of these others. And so photos are often taken more than anything. You know, I take photos for, as a amateur, pro-amateur photographer for my son's school, for his karate dojo. You know, I constantly taking pictures of things, and I put them out there, and I'm telling people, feel free, take them. You know, I don't care. And then I sometimes feel bad because there's the guy standing next to me at the karate show. That's his living. You know, he's selling those photos, and I'm sitting here taking pictures, and I'm giving them away for free. So now, you know, I say to Rick, I'm like, Rick, take, you know, here's a copy of everything I took. If you want to sell any of these, go right ahead and sell them. You know, I'm giving them to my friends and people, but people that don't know me that are going to come to you, go ahead and make money off of it because I feel bad, like I'm taking away from his livelihood.
So we often do PowerPoint presentations. We'll have, you know, all these nice pictures, and we want to put a song on there that goes with it. How do we get permission then so that we can attribute the song? I mean, you know, we're going to have Barry Manilow's song on
Right.
there.
Call Bruce, he'll help you. No, so there are, in the case of music, there are processes to license them from ASCAP and BMI to get those rights. You know, we've all heard of the term Muzak, right? You know, there is actually a company whose name is Muzak. And when you pay, like I own a hotel, and the hotel plays music in the background, and we had to pay a license and buy equipment from Muzak to play music. They are handling, every time a song plays, recording that I have in fact played a song and that I owe a license fee, and it's in my monthly fee. It's just part of what I'm paying for. In the case of a PowerPoint, you're not going to go through all that. And in the case of a PowerPoint that's going to be used for internal educational purposes, you're probably never going to be practically identified that way. The moment you start putting it out on the internet, the moment you start, you put it out on YouTube. Now, you know, YouTube has now even started looking for the fingerprints of these songs, and they will actually block your uploads until, you know, you can show that you have the rights to do it. And so through ASCAP and BMI, you can actually pay a fee to license it for the particular use. It's, to say that it's not done very often is an understatement.
Yeah, because like for liturgical music, you know, we know that there's liturgical, you can get a license for one company and you pay a fee. But if we're just talking about one song.
Right. Yeah, and the usage is usually pretty small too, right? You know, what's the extent of the usage? And so they don't get paid this much money as a blanket. Like if you're going to put your song into a movie, the movie has to pay, and the fact that it's going into this movie and that the movie is going to be shown to so many theaters and it's going to then go on to DVDs and then it's going to go. So there's an agreement that they sign, you know, for it. When you're going to put it in a PowerPoint presentation that's going to get shown in 20 classes and maybe put up on a YouTube video that gets a few hundred clicks on it, the amount of the usage might be so small that.
Right. And if you're going to use something like Taco Bell's Canon, that's.
Yeah, the old expired copyright rights in the underlying music.
Yeah, that's called.
It's public domain at that point because, yeah. Now, if you use a recording of the New York Philharmonic recorded last year, even though Taco Bell's Canon may be an expired copyright, it's a new recording that you're using that may have its own copyrights.
So if you cited it at the end of the recording and then put it on a diocesan website, that might get more hits.
And
Is that naughty?
it's
Just one.
We're still trying to find the line.
yeah, it's an example where doing that is safer than putting it on YouTube, you know, or using a service that hosts the video, but you're not publicly displaying it on their service like Vimeo, but you're using Vimeo to power the videos on your site. And the fact that you're purely, you know, in general, people don't want to sue churches. They don't want to sue religious organizations. They don't want to, it doesn't bode well for the media. But with that said, if it's the guy who has the television show on Saturday morning with 4 million viewers, they may care more. So the nature and scope, the fact that it's not for profit, the fact that it's religious educational purposes, the fact that you're not using the entire record, you're using one song, or you're using 2/3 of the song, the fact that it's not the sole basis of what you're doing, it's not like if you were a church who is creating a radio station and you're playing music to have people listen in, that's the basis of your business. That's different, right? So you put all those pieces together, the only thing they could really hold their hat on is you're taking away their commercial use. But you would argue that my PowerPoint presentation or my video that I did that has this as an underlying is not taking away from, from their commercial use that they would otherwise have, and therefore should be protected under fair use.
So the church is fairly well protected under fair use because they're not making a profit, they're using it for education and other things.
Yeah, that's what I said. You guys are like in the best position because you have that first factor pretty well cold, right? You don't have to worry about the argument like a university, where you're making money off of inventions coming out of your engineering school that these students are paying $50,000 a year for, yet you're copying articles to give to them. There's so many steps between money making and the fact that they're not for profit, where religious organizations generally have more proximity. It does get a little bit more complicated if you have something like thrift shop or Goodwill or something where now you're playing music in the Goodwill store. Now have you gone into the not-for-profit to the for-profit, but the ultimate use is for not-for-profit.
So with image sharing and doing social media stuff, people click more when there's a picture associated. And with products like Microsoft getting away from having their own clip art library that create, now Bing and Google have all these search filters on
right.
photos. I struggle sometimes with knowing, like, where do we fall under, what's the right filter to pick? Right.
It is tough. I'll tell you, I have a software company, among many of my hats, and my software company will use images in our product, and I always tell people in the company, we can't use Google to find an image and say, oh, that's in the public domain because it's on Google. We have to go to iStock Photos or Corbis or Getty and license one of their photos because we're a commercial enterprise. We're making money on our product. It's important. Again, you're in a different position because the purpose for your doing it is for perhaps drawing attention to a religious or academic, program, content, something you're doing. And, yeah, a lot of people, they search through Google, they search through Bing images and download and start posting it.
Different, like free to share and use, free to share and use commercially. Yeah, there's like the Creative Commons license, there's the free, totally free license. Most of the arguments for one or more of those licenses are going to have more impact on the commercial users because your arguments for fair use, if you have one of those extra rights, that's even stronger. Like, why would you come after me? There are all these rights that you're giving people to use it either for free or free with attribution. I'm a big fan personally of attribution. I think it helps avoid it shames people, right? If you give them attribution for the work, you at least have the argument that I'm bringing attention to you and your work. It just feels better.
What about when you click on a picture and an image and it says may be copyrighted? And I've tried to follow the copyright, find out, well, is it or isn't it? And
the sheer fact that it exists, default, it probably is protected by copyright unless it's so old that it's in the public domain because it since has expired. It may be protected by copyright but then be subject to a free-to-use license. But creating creative expression fixed in a tangible medium, copyright vests.
Silly question. Is royalty
Only silly answers.
is royalty free? Same as cable and share?
So in the true legal sense, there are licenses. And when you have a license can be for a term, or it can be perpetual. It can be royalty-free or subject to a royalty. Some people get them confused. They think that those are the same. But I could have something that says you can use this perpetually, subject to paying me a royalty. I could have something that says you can use this for a term, but it's royalty-free, right? They're not the same concept. So when it says royalty-free, it means they're willing to give a license without you paying for it. Does that mean that you have the right forever? Maybe, maybe not. Depends on, is it a term license and what other, the license. So in the case of software world, you've probably heard of things called open source. And the idea behind open source is it's royalty free, but ... and it depends on what the open source license says. Often the open source license says you have to give me attribution. You have to distribute a copy of this open source license with your code. You have to, if you incorporate this in, your code now becomes part of the open source movement. So depends on what the terms of the actual license say. But royalty-free is really about, do I have to pay for it, as opposed to term, which is it perpetual or for a specific period of time. Anything? Thank you.
Thank you.
If you have any questions and want to come up, I'm happy to answer them. If you have any questions down the road, I guess my contact info is not on there, but if you all know Kishmish, Matt at Kishmish, he knows how to get a hold of me, and you just ask him and he'll give you my contact info.
Okay, thank you.
Sure.
Yeah.
Thank you.